You seem to put quite a bit of weight on the use of the word right over, I think, 20 times in Tlefsky, and the absence of the word right in this case. Do you think right is absolutely necessary in order to determine whether or not a right has been created under this provision?
I think if Congress wants to be clear, right is the best word, but we would take its functional equivalent. So, for example, entitlement or privilege, other words that are functionally equivalent to right, or, of course, the traditional no person shall, like the Fifth Amendment. But this court made clear in Tlefsky that this is a high bar. It's atypical. And so if a state is going to be on clear notice, which it has to be to know what contract it's agreeing to, it needs to be really clear.
So how would you amend this statute to be clear about a right?
There's a number of things that Congress could have done. For starters, it could have set it apart in a separate Bill of Rights, like it did in Tlefsky with its provider choice provision. It could have used rights-creating language. For example, a beneficiary has a right to designate her provider. It could have taken the qualifications of the provider away from the state, the regulator, and instead made it a federal issue. Or it could have even done something like Congress did in 1396 small a, A84B, which if you move all the way down the list to near the end, it took the regulated entity, the state, it used a rights-creating shall, and it put them together in the provision. But none of those indicators of a clear statement is present in this provision.
You're not quite calling it a magic word, but you're coming very close. And an example was raised in one of the briefs that says the IRS must provide that any individual may obtain a refund of overpaid taxes. It seems hard to believe that that sentence on its face does not create a right for an individual to have a refund of overpaid taxes.
Justice Sotomayor, let me address the magic words premise and then the IRS hypothetical. With respect to the premise, I'm not going to fight the court if you say that these are magic words, because that's really what
No, you would like us to, but assume that I don't want
to. Yeah, that's a clear statement rule. That's what states need. But in the IRS hypothetical, there's a number of problems with that. First, as we point out on page 9 of our reply, it could be clearer. But more important, the IRS provision is not a spending clause provision. It's not this conversation between a state and the Secretary of Health and Human Services about what must be done.
It seems a little bit odd to think that a problem that motivated Congress to pass this provision was that states were limiting the choices people had. Some states were saying only state facilities would provide the benefit. Other states were identifying a more limited subset of providers. It seems hard to understand that states didn't understand that they had to give individuals the right to choose a provider.
Justice Sotomayor, certainly a state would understand it has to provide a benefit, but absent clear rights-creating language, it wouldn't know that it had to honor a right. And I can make that same statement about what's important to people or what's significant about dozens of other provisions in 1396A. If you're talking about equal protection or the right to services, how about being reinstated on the Medicaid program after you've been in prison? There are countless things in that statute which people would consider important and vital, fundamental. None of those words actually appear in the any qualified provider provision.
In your brief, you had 8 provisions of the Act that were part of this same list of rights, and you said, if we recognize a private cause of action here, these 8 are open to dispute. I looked at the 8 very carefully, and there hasn't been much of a dispute among the circuits. There hasn't even been a challenge. You mentioned one of them, because it's hard to see how a state can't understand it. There hasn't even been a challenge to it about providing Medicaid to juveniles in prison. And there's been no dispute over that because no one doubts that the state knows what it has to do, and it doesn't. The others, again, none of them have disputes. Some uniformly, the courts have said don't create private rights, and others they have said they do. Where they say they do, to me, it's a simple issue. you have to provide a fair hearing before the state agency of any individual who claims coverage. Most states have a hearing of some sort. But so I don't understand why that is important here.
It's the difference between a benefit and a right, and whether this court is going to hold the line it stated in Talevsky that this is going to be atypical when Congress creates a right without using the so-called magic words.
Well,